Welcome, everyone. I'm so pleased you were able to join us today. Before we begin the program, I'd like to go over some housekeeping matters. First of all, I'm Lori Nelson at the University of Utah College of Law, and I'm pleased to welcome our speakers, Adam Crayk and Ysabel Lonazco, to present to us. At the end of the presentation, there will be a time for questions. Please put your questions in the Q&A and not in the chat. The chat isn't being monitored, so please put them in the Q&A. If you like a question or is similar to one that you would ask, you can go ahead and like it, and that question will rise up in the queue. Also, pursuant to Utah Supreme Court rules, you have to stay on for the entire hour in order to get credit for the CLE. Last but not least, if for some reason you bounce off and you sign in using a different ID, for example, you signed in originally using your email and then you come back using your phone number, please email me at lori.nelson@law.utah.edu so I can make sure to combine the two separate IDs and give you credit for attending. You don't have to email me that you attended for any other reason. Anyway, thank you so much. This is the first of our intersection series for 2024, and I'm very pleased and grateful that Adam and Ysabel have agreed to present on this topic. So I'm going to start this off and turn it over to Ysabel. Thank you very much.
Hi, good afternoon. My name is Ysabel Lonazco. So what I'm going to do today is I'm going to give you an overview, definitions, so I can let Adam take over later. So we're going to go over definitions such as what is crimmigration. We're going to go over the definition of what is a conviction, what is inadmissibility, what is deportability. Anyway, so let's get this started. I already told you what crimmigration is. It's the intersection between criminal law and immigration. So it's basically a way in which criminal convictions are being used to subject immigrants to removal proceedings and deportation. Who does it apply to? Who does crimmigration apply to? This applies to any citizen that has non-citizen who has committed certain crimes. So basically, any immigrant who is in the United States that has been arrested, convicted, has pled to a crime should be concerned. So, for example, people who enter the United States with a visa, tourists, international students, people who enter without the proper documentation, they are also non-citizens. People who cross the border without being inspected by an immigration officer. Also, it applies to people who are lawful permanent residents, people who have a green card. For example, you could be a green card holder for 20 years and still be subject to deportation. Now, let's define what is a conviction for immigration purposes. Where there's a formal judgment of guilt of the alien entered by a court, or if adjudication of guilt has been withheld. What does this mean? It means that a judge has found you guilty of a crime, or you pled guilty to a crime. But also, you can see on the slide, there's or, and then there's an and at the end that says the judge has ordered some form of punishment or penalty or restraining the alien's liberty to be imposed. So that's the definition of a conviction that I want you to have. So it must involve finding of guilt and some punishment, some restriction of liberty for it to be a conviction. Let me go to the next slide. Now, determining the status, that is a very important part of whether this person, this non-citizen, is subject to deportation in this case, is it inadmissible? Is this person inadmissible? Is this person deportable? We'll go over those definitions in the next slide. But you want to ask your client, you don't want to assume whether this person entered with the proper documentation or without the proper documentation. So this slide show you on the right, on my left side, somebody entering with a visa, right? A visa stamp. So you go through the airport, you go through the port of entry. So you have an officer that is inspecting you to enter the United States. Now, on the right, my right side, you can see the border. So this applies to people that enter without the proper documentation. Okay? So first question you want to ask to see whether crimmigration is going to apply to the non-citizen is, how did you enter the United States? That's gonna be the most important question to know whether what grounds is the government trying to charge my client under? Because the immigration relief is going to vary depending on whether you are subject to the inadmissibility grounds or deportability grounds. Okay. So let's define what is inadmissibility first. So it is a legal fiction. Basically, the mere physical presence in the US does not mean that the foreign national lawfully entered the United States or that was admitted to the US. You had to have been inspected by an authorized immigration officer to be admitted. So there are people in the United States that are here physically, and even though they have been here for 20 years, 30 years, they may not have been admitted. So don't assume that because this person has 5 US citizen children and has been here for 45 years, it means that they have an admission, okay? So people who are inadmissible are subject to INA 212A2. So it applies to people that seek admission to the United States. Who is subject to these grounds? Let me go a little deeper into that. So people that are undocumented and enter without inspection, applicants for admission at the border, such as non-immigrant visa holders, people that are arriving to the US for the first time, applicants for adjustment of status, applicants for other type of relief, such as U visa, T visas. Now let's go to my right, which is deportability. Deportability is regulated by INA 237A2. This applies, if you remember, so my left side is deportability, my right side is inadmissibility. So right now we're going over deportability, which means people that have been already admitted to the United States. And again, I say admitted because we already made it clear that people are admitted by regular procedure by being inspected by an immigration officer, right? So the foreign national has been lawfully admitted to the US and then commits a crime. So then they are subject to the grounds of deportability, okay? So let me give you a little bit more of detail. Who is subject to the grounds of deportability? Non-immigrant visa holders within the US following a lawful admission. So you enter the United States with a student visa, with a tourist visa, so you are a non-immigrant visa holder entering. So after you were admitted. People admitted as visa waiver entrants, visa holders, or visa waiver overstays in the United States. Lawful permanent residents are also subject to the grounds of deportability. Okay. Now let's go. I already told you the definition of what a conviction is. We went over what inadmissibility is, what deportability is. We're gonna now go into what type of crimes are gonna trigger deportation. So we have aggravated felonies, crimes involving moral turpitude. What are aggravated felonies? Aggravated felonies are the category of offenses that carry severe immigration consequences. The Immigration National Act, the INA, lists 21 crimes that are considered aggravated felonies. I have listed just a few. like murder, rape, drug trafficking, firearms trafficking, money laundering. On my right side is CIMTs. Excuse me. So crimes involving moral turpitude, there's not a definition of what a CIMT is in the INA, but they are offenses that demonstrate a lack of good moral character. There's not a comprehensive list of CIMTs in the INA, but they typically involve some type of fraud, theft, or offenses with the intent to harm others. Some examples include aggravated assault, burglary, domestic violence, fraud, forgery, and sexual offenses. We go to the next slide. Okay, so now we keep going a little deeper into this, and then we're gonna go into the criminal inadmissibility grounds and then deportability grounds. We define what people are subject to inadmissibility and what people are subject to deportability. Now, who is subject to this? When you commit a crime and you are a person that are subject to inadmissibility, these grounds will prevent you, a non-citizen, from being able to obtain lawful permanent status in the United States. It may also prevent you, if you want to obtain any other lawful status, from being able to return to the United States from a trip abroad. So we discussed CIMT in the last slide. What CIMTs are in the inadmissibility grounds? These are offenses with intent to steal, defraud, offenses in which bodily harm is caused or threatened by intentional acts, or serious bodily harm is caused to threatened by reckless act as well. So most sex offenses are CIMTs. Now we have, if you are in admissibility, if you are in the left side of this slide, it means that the petty offense exception applies to you. What is the petty offense exception? It means that if you committed a CIMT, and you don't have any other, you just have one, the offense is not punishable, it's less than a year, the conviction, the restriction of liberty, the punishment that the judge issues is less than a year, and does not involve a sentence of less than 6 months. So if you're inadmissible, if you are in that side, not subject, this exception does not apply in the deportability grounds. Now, another type of inadmissibility ground is people that commit controlled substance offenses, multiple offenses, like a conviction of 2 or more offenses of any type, and the aggregate prison sentence of 5 years. Prostitution is another inadmissibility ground. Let's go now to deportability. For deportability, it will or may result in deportation of a non-citizen who already has lawful status in the United States, such as an LPR, a lawful permanent resident holder, or a refugee. In this case, how does the CIMT apply for people that are subject to deportation? So say that you are an LPR and you committed a crime within 5 years of admission into the US, and for which a prison sentence of 1 year or longer may be imposed, then you trigger a deportation ground there. If you committed 2 crimes at any time after admission, 2 CIMTs, anytime after admission, not arising from out of a single scheme. So you have those 2. You see the difference in this chart. It's clear that you are treated different because you were admitted, and you are treated in a different way as well if you were not admitted. So you also are subject to a deportability ground if you have a controlled substance conviction. except a single offense of possession of 30 grams or less of marijuana. Firearm offenses also trigger deportation. Conviction of domestic violence also can trigger deportation, only if it meets the definition of crime of violence. Let's see, aggravated felonies also can trigger deportation grounds. And this is my last slide. So I just wanted to give you a quick example to cover everything I just discussed. So this example says Carlos, who is a non-citizen, entered the United States in 2022 with a student visa. In January 2023, he was charged with a felony for robbing a house, a not felony. He pled guilty to a third-degree felony, and he was sentenced to 5 years. The prison time was suspended. So now let's apply crimmigration to Carlos. The first question that I told you we should ask as attorneys is he a non-citizen? How did he enter the United States? We know that he entered with a student visa, so we know he triggered, he's subject to INA 237, the grounds of deportability, right? Now, does he have a conviction? That's the next question we want to know. Yes, there's a guilty plea of a third-degree felony. The penalty ordered by the judge, remember that in order for it to be a conviction, there had to be a guilty plea, and there has to be some sort of restriction on liberty. So he was sentenced to prison. So the answer is yes. Is he subject to deportation? Did he trigger deportation? Immigration will punish Carlos and they will seek to deport Carlos from the United States. And I hope I'm gonna let Adam continue with the presentation. Thank you so much. Adam, do you want me to keep these slides open or? Up to you.
I'm still trying to figure out how to take myself off mute, which now I've figured out. Technologically, I'm not that savvy. Yeah, because I want to show some nuances. Would you go back to your list of aggravated felonies and CIMTs?
Absolutely.
All right. And I want to show you guys, let's see, no, go back to your actual list for where it has the enumerated crimes.
Oh, okay.
Right there. All right, guys, I want to make sure you guys understand a distinction here. In Utah, burglary doesn't have to be a CIMT, nor does domestic violence. And there are sexual offenses that are not CIMTs. Aggravated assault is straight up a CIMT. Fraud and forgery can be both a CIMT and an aggravated felony in the state of Utah. So I want to make sure everybody understands that while we have general lists and while we do list certain enumerated offenses, welcome to the world that not anything that you say it is actually what it is. So in my world, I perpetually spend all my day, and I'm kind of a nerd. I get that. I understand it. But diagramming the statute to determine whether or not there's an intent to do certain things, whether or not there's an intent to deceive, perform fraudulent services, all sorts of different kind of crossroads. And crimmigration it's funny. The immigration code, there's only one code that's larger, and it's the tax code. So in the immigration world, the most poor destitute of all are subject to the second largest code that we have in United States law, which makes immigration in and of itself a real interesting area of law to practice. But then you throw on top of that all of the criminal codes, and you have a recipe for disaster, especially when you're representing those in criminal court who have certain types of status. And I want to make sure we understand everything. Generally, you're going to run across people, like Ysabel has pointed out, who are undocumented, who have DACA, who are applicants for a U visa or a T visa, meaning they're U visa, they're a victim of a crime. T visa, they're a victim of human trafficking. You have a lot of people now who are jumping into the asylum world. So you are aware right now the immigration court has over 34,000 people in deportation proceedings. I know that because one of the judges constantly announces that he has over 10,000 cases. I love him to death, but he tells me every time we're there that he has over 10,000 cases, which is funny. It's not funny, it's a shame, but we're over 30,000 people. And a lot of those are refugees. And to be perfectly honest, there are scenarios on refugees where things are totally different. So like you get refugees from Venezuela, and I'm using a term, so they're seeking asylum in the United States. They haven't actually been designated refugees yet, but they're seeking asylum in the United States. And there are ways to look at every single case or every single type of status. For example, TPS, temporary protected status, is another category. So I want to make it abundantly clear, when you get someone in your office and you're interested in representing them, you absolutely have to understand if they have status, if they're applying for status, have they applied for status, and in what type of status they find themselves. Because my answers will vary. One of the things that I do is I have the contract for legal defender's office here in Salt Lake County. And I get about, I don't know, in between 5 to 6 texts every day. And then on a weekly basis, I get probably 100 emails proposing scenarios that they're trying to resolve, that the legal defender is trying to resolve with the prosecutors. And in fact, I'm resolving one right now. I've been texting back and forth with a juvenile prosecutor, and somebody in my office gave advice that I don't necessarily agree with, but that's the world we find ourselves in. So let's kind of dive in for Utah. One of the primary crimes, and I just presented on this down in Southern Utah for the misdemeanor court prosecutors. One of the issues that a lot of prosecutors get is the questions about DUI, and you guys that are going to represent people that are in a DUI case. Please, please, please be careful when you say to the prosecutor that the DUI is going to get my client deported because of the statute itself. That's simply not true. That's not a true statement. And the prosecutor, I've been quoted now, and I've had several defense attorneys call or send me an email saying, why are you telling the prosecutors that a DUI is not a deportable offense? And I'm going to explain why it's not. So for any of you that know about DUIs, you know that our statute requires two things, one of two things. It requires, well, more than that. It requires the person to be in actual physical control of a vehicle, that the person have a BAC or B-RAC in excess of 0.05. That's all it requires. That they, or that they are incapable of safely operating said motor vehicle because of their level of impairment. So you could actually have someone that was cited for DUI that had less than a 0.05 because the officer observed a driving pattern or some sort of observation that he believed would safely render them incapable of driving a motor vehicle because of their impairment. Did you hear any language about intent there? No, you did not. And the reason you did not is because in the state of Utah, DUI is a strict liability crime. So when you have a person who is cited and the crime is a strict liability crime, you are safe to conclude, extremely safe to conclude, that that crime is not a crime involving moral turpitude, nor is it a crime of an aggravated felony category. Even if it's a felony, and we'll talk about one that is a felony, for example, unlawful sexual activity with a minor. That simply says if you engage in sexual activity with a minor, and that's the F3, if you engage with sexual activity with a minor and it's F3 and Class B, you are simply guilty. Doesn't matter if you intentionally, knowingly, recklessly, or negligently perform that activity. It doesn't have a mens rea. So that one, actually, we have a 10th Circuit case on point that talks about that being that it is a safe plea, which would seem so counterintuitive, but it's simply the case. One of the things that are listed on there, and I'm trying to go into the kind of the most discussed types of crimes. We need everybody to understand something. If you are undocumented, we're going to go into marijuana real quick because everybody deals with marijuana. If you are undocumented and you come into the United States undocumented, if you are charged with and convicted of a marijuana-based offense where you simply possess marijuana, you are barred for life. Okay, I want everybody to understand that. If you have an illegal entry, you are barred for life. There is no fixing that per se, unless there is a certain type of crime that you become a victim of, or certain types of other types of visas you might be entitled to. But if you marry a citizen and that citizen wants to fix, or if your client marries a citizen and that citizen wants to get a waiver with an undocumented entry, that's pretty much going to be a very difficult proposition with an undocumented entry. Now, if you come in legally, there's a waiver for that. You can get a waiver because you possess 30 grams or less. But it's very nuanced. Please understand, if you have a client charged with pot, there is an exception here. I'm going to give you away some secrets. In the Utah State Controlled Substances Schedules, there is a drug called HU 211, HU-211. That drug is not listed on the federal schedules, and it is spice. And our statute, our marijuana code, says that you were in possession of marijuana/spice. While it is somewhat of a legal fiction, it is a very viable and useful legal fiction because it will render them eligible for all benefits and they will not be barred. So that is an alternative that we persistently and consistently use to try and ensure that our clients are given a shot in this life in the event they have some type of the ability to adjust or fix themselves. It's interesting. But also if your client, and I'm going to give you a scenario, if your client is a legal permanent resident and he gets a pot conviction, he is deportable or she is deportable. And just anecdotally, I represented a young guy, it's been about 7 years now, in Logan. And this young fellow decided to get 2 pot convictions, and he was a permanent resident. Well, he committed those 2 pot offenses within his first 5 years of getting his green card, which means he doesn't even qualify for what is known as cancellation of removal because he doesn't have the sufficient time within the United States without a crime-free existence. But he enjoys the marijuana. And he had no idea. He was convicted of these 2 charges. And the next thing he knows is the ICE agents show up on his doorstep, and they were nice because they didn't take him into custody, but pot is a mandatory detention offense, even for a permanent resident. So they will take you into custody if you have a pot conviction. But they didn't take him into custody, but they did issue him what is known as a notice to appear in immigration court. And so he was sent to immigration court. And as his case presently stood, he had 2 convictions for pot. He was ineligible because he couldn't readjust, meaning he couldn't adjust again because he was over the age of 21, was not married to a citizen, and it was his mother that got him status. There's a long waiting list if she wanted to file another petition, and there's a lot of nuances, so forgive me, I just got to set up the story just to kind of make you all see how stupid this can be. But he was going to be deported, and nobody could stop it. So because of these 2 pot convictions, I went back to the prosecutors in Logan and explained to them, hey, this kid's going to be deported because of these 2 convictions. And nobody did their due diligence on Padilla, which hopefully everybody's heard of Padilla versus Kentucky, which since 2010, everybody has an obligation to make sure their clients are sufficiently informed about immigration consequences, or at least give them the opportunity to speak with an immigration attorney. And I would say more crimmigration attorney, give them the opportunity to speak with a crimmigration attorney. But this young man didn't have that opportunity. So the prosecutor says, well, so I'm not really, he's pled guilty. He was in possession of the pot. I don't really need to do much about that. Well, I said, well, we could file an ineffective assistance of counsel case against the defense attorney. He didn't do anything to let the guy know that he was going to be deported. And I said, okay, I got a fix. How about we presume, because chances are pretty safe, that this young man was driving a vehicle with marijuana in his system. So how about I do you one better. I will take your 2 pot charges and I will raise you 2 DUIs. We're going to eliminate the pots and we're going to have him plead to 2 DUIs. The prosecutor's like, are you nuts? That's for sure malpractice. Like, okay, yeah, sure. I will still do it. Trade me those 2 convictions. Let me withdraw the convictions on the pot charges and let me have him plead guilty to 2 DUIs, straight up DUI. And I'll even let you put him in jail for 10 days because of the second DUI's mandatories at the time, 10 days jail. Prosecutor says, okay, fine. So we redid the paperwork, withdrew the guilty pleas, filed on the filed the DUIs, and then I filed proof with the immigration court that he had accepted and had his guilty pleas withdrawn on the pot charges for failure to receive Padilla advice. We then resubmitted the paperwork showing that it was 2 DUIs, and the immigration court, through what is known as OPLA, dismissed the immigration case, completely dismissed all charges. The young man was no longer in deportation proceedings. Now, in the normal world, all of us think, how in the world is that even remotely possible? How does that even make sense? Well, to be candid, it doesn't. It simply does not. But that's the way the code is written. So let's go into the next thing that we handle a ton of, domestic violence related offenses. Okay. Those are really important for the state of Utah. And let me tell you why. All of us know in the state of Utah that for pretty much every type of assault, criminal mischief, electronic communications harassment, unlawful detention, we have a presumptory mens rea statute that says intentionally, knowingly, or recklessly. So back in the day, we had a case that was the Betcher case out of the 10th Circuit. Betcher said, guess what, guys? Domestic violence related offenses, they are crimes involving, well, they're not even that. They're violent offenses. Okay, they're crimes of violence, which is more akin to aggravated felonies. And it basically, for a period of 2 years, we had this issue where I was telling everybody, you can't have a DV assault because there's an injury, there's something that's happened, and they're considering it a crime of violence because there was not a distinction with Betcher. But then the Supreme Court comes out again with Belcher and says crimes of violence cannot have a reckless mens rea. It has to be intentional and knowing. So if you're now negotiating and you have an issue of domestic violence and you're in the A, B, and C arena, misdemeanors, my initial inclination is always to try to get rid of assault. Okay, it is. It's just always, because there's some other reasons, and we'll go into that for a sec, but there's some other reasons why we want assault off the table. But if it's simply not coming off the table and everything else is getting dismissed, but they're giving you a DV Class B misdemeanor for assault, that is something that can be accepted, and it would fall, number one, under the petty offense exception, but it's also not argued in immigration court anymore in the state of Utah that it qualifies as a crime involving moral turpitude. It's simply not. So I have lots and lots of cases where my clients have DV assaults in deportation court, and the government, they do not fight that point. They don't fight it on DV unlawful detention. They don't fight it on anything where the presumptive mens rea is reckless, except for aggravated assault, because, or they fight that one because the level of the offense is likely to produce severe bodily injury and or death. And they think that type of behavior, and the court has found that in matter of what's called OH Hernandez, that level of harm does rise to the level of egregious, violent, horrific type of behavior, that it does meet the threshold for for a crime involving moral turpitude. So there's a nuance there, and I know I'm so sorry we only have an hour to go through this, but there is a nuance there. So if you find yourself in just the Class B arena, which I hope most of you do, the DV assault can be taken. But let me tell you why I try to avoid it. All of those people, they look at those, when I say they, I'm talking about ICE, those people with a domestic violence related offense. They kind of become a little bit higher priority for arrest, not because of the language of the statute, but more because of a public safety concern. Okay. And that's the same with DUI. It's not a deportable, not a removable offense, but it is a public safety concern type of offense that they want an immigration judge to determine whether or not that the people should be let out of custody. Okay. So while it's not a mandatory detention offense, it's not a mandatory stay in jail offense, a lot of the time my clients that get taken into custody and we're disputing a DUI, I have to prove two things with the judges and DV related offenses. I have to prove that the person is not a danger to the community, and I have to prove that they're not a flight risk. And to be candid, if the person has one recent DUI, my job becomes a little difficult because they think that the person's willing to drink and drive. So I have to get them out of custody, and that's a little bit difficult. Doable. When I get to 2 and 3 DUIs, it's pretty much not going to happen. Again, not because it's a crime involving moral turpitude, not because it's an aggravated felony, but because the immigration judge simply believes that the person should not be released because they are a danger to our community. So those are the kind of issues that you want to also address. And the prosecutor will say to you, well, I know DUI is not a deportable offense. And you say, you are right. I understand that. But what it does do is it makes the person a person that is a danger to our community. So a lot of the time what I do there to ameliorate or mitigate those circumstances is I will draw the case out quite a while. If the prosecutor is willing, I will tell them, look, we're going to take your deal, but let me tell you what I anticipate doing. I'm going to get my DV evaluation done first. I'm going to get my person into treatment. I'm going to get my person into the mandatory 16 weeks of classes. I'm going to get the certificate of completion to the extent that I can. And then that sets the person up for a much better argument in front of the immigration judge that they have taken the offense seriously, that they have done everything in their power to mitigate what their actions were, and that they are now repentant, and the judge can see that they did take it seriously. Same with the DUI. I will never, ever, ever take a case where I have someone that's undocumented or someone that faces removability or removability specifically, because deportability doesn't exist on a DUI, but I will not let them plead within the first month ever. And it's not a tactic to delay. It's simply a tactic to make sure, because I know the long game. When my client is going to be in front of the immigration judge, that immigration judge, and take this, they are way more conservative and way more concerned that if they let the person out of custody, being someone that doesn't have any status, that person drinks and drives and kills somebody. For them, it's 10 times what your normal justice court, district court judge is thinking and feeling. The immigration judge takes it way more seriously. So tactically, I will not ever let someone plead within a month of being charged. You just don't do that. You simply get them into treatment, as much treatment as you possibly can. There are certain courts that will allow for the 24/7 program because they have driver's privilege, the client does, and that's the only impediment to reinstating. So we do that. Same with domestic violence. We get them evaluated. We do everything we can. Not with pot. With pot, we simply ask for alternatives. We ask for paraphernalia or we ask for HU 211, and I know I discussed that. When we're talking about the next kind of category, which is theft, really, guys, there's only one really, really, really good alternative there, because theft is both an aggravated felony if it's a sentence for 1 year or more, and it is a crime involving moral turpitude. Okay. Now, I get emails all the time that say, but Adam, they're offering me a plea in abeyance to this theft charge. And like, great. but it's still a crime involving moral turpitude and still a conviction for immigration purposes. So to all of you who practice in criminal law, pleas and abeyances for state purposes are fantastic. They mean absolutely nothing in the immigration context. They are 100% a conviction. Now, there is a distinction there, because if they're not willing to offer what I would call wrongful appropriation, but now it's unauthorized possession or control of the property of another under what is known as 766404.5, that's the statute we use with regularity. They're not willing to amend to 766404.5, and it's a theft charge that's a class or a felony 3. If you get that to a plea and abeyance and there's never been, and they don't violate, well, no sentence has ever been imposed, right? So there's no jail hanging over the person's head. It's not been imposed. So there is a plausible argument there that it still meets the petty offense exception because no sentence was imposed. Okay, so there are ways to work around the system. There are ways to argue around the system. But then they say, well, but yeah, 0 to 5 could have been imposed. And there is some argument in the CIMT arena in that category. But if you don't have a choice and a plea in abeyance is being offered, it's better than nothing because no sentence gets imposed. So you were never given 365 days. So you can argue that it's not a crime of an aggravated felony arena. On the fraud front, just know if it says fraud and it is the value of the loss exceeds $10,000, it is going to be an aggravated felony. And if it has the word fraud in the statute, meaning intent to deceive, you can pretty much take it to the bank that it is going to be a crime involving moral turpitude. So anytime you see intent to deceive or intent to deprive permanently, you know you're dealing with a crime involving moral turpitude. I don't know how much you want me to go into sexual offenses. I can't see all the participants, so I don't know the level of the criminal defense type crowd. Normally I can see faces or see participants' names, but let's do a little bit discussion of sexual offenses. On the sex offense front, there are a couple, there's about 3 that are valid, viable options. First, and number 1, sexual battery. It's a Class A misdemeanor, but it works in every context. The mens rea on that is that you did something knowing that it would cause affront or alarm. Sexual battery is a very viable option, and it's one that you can really, really use when needed. As I had mentioned before, unlawful sexual activity with a minor as a Class B or even as a 3rd-degree felony, that's a strict liability crime. There is no mens rea there. It can be used. I have a new one that I was just able to kind of figure out, and it works, and I got agreement on it. And this one, you're all going to be, it doesn't make sense, but forcible sexual abuse, not of a minor, but forcible sexual abuse. Okay. It's a 2nd-degree felony. I have a case right now where my client is charged with attempted kidnapping of a child. Okay. And it's not the greatest case. The judge even thinks that it's more of a solicitation case. But my client is an LPR. He's a legal permanent resident, been in the United States for literally 30 years. He argues he was just trying to provide assistance. The CJC interview, if all of you know what a CJC interview is, the CJC interview wasn't great. Facts aren't great, but the potential for deportation and prison are also there because it's a child. So going through the code, we were looking at it, and forcible sexual abuse, it requires very little, meaning it requires very little. You don't even need to, it's touching over the clothing. Doesn't have to be a minor. It's akin to sexual battery. I did my homework. I called OPLA, went through one of their attorneys. We hammered out that statute, and I said, hey, listen, I need to understand something. If I do this plea, I'm presuming that I'm safe, that no NTA is going to get filed. And he's like, yeah, I don't see how I file on this. I really don't. So In the most rare circumstances where some of you guys handle those types of cases, forcible sexual abuse is a very legitimate, viable now option. If you need to get up into that upper arena of felonies, forcible sexual abuse can work. Quickly, violations of a protective order. Guys, never. And one more thing that I need to address, don't ever, and I would need to imagine in your minds, I said ever, like 55 times. Never, ever reduce something with attempt. Ever. Because you have literally taken what is a reckless mens rea to do something and have converted it into an intentional act. You can't attempt something recklessly. You do it intentionally when you attempt to do the very thing that you're accused of doing. So hopefully all of you know that there is a case called West Valley City versus McDonald, which allows you to reduce the level of the severity of the offense by one level simply by saying, Judge, we are reducing this under West Valley City. That's the way you do it. Please, please, please don't make me have to file something against you that says they did this under the attempt statute, which made it worse. Please, please, please don't do that. All right, so back to violation of a protective order. We don't do attempted violation of a protective order. If you want to, and violation of protective order, guys, has its own category. So let me tell you the option that we use there. In the immigration code under 237 and 212, a violation of a protective order requires that the order be issued by a judge. Now, if I had all of you in a room, I would ask, okay, is there anything out there that's similar to a violation of a protective order that kind of accomplishes a protective order that kind of accomplishes the same thing that's similar to it? Well, there is. It's a jail release agreement. But who issues the jail release agreement? The jail. So statutorily, there is a very large distinction there. You can, if forced, you can accept a violation of a jail release agreement. And even if it's a DV violation of a jail release agreement, it doesn't make it any worse. It's still the statutory context that they were issued a release agreement by the jail not to contact the victim. They initiated the contact regardless. But again, one is issued by a judge, one is issued by a jail. And the one issued by the jail, very, very good alternative to accept. Next thing on forgery. And a lot of the time we get the people, and the AG's office primarily brings these types of cases. It's where someone complains that their social security number is being used, and you have to figure out, okay, they typically are charged with a second-degree felony for identity fraud, and then they're also charged with forgery, right? So what is a good alternative in that category to accept? Number one option, highest priority on that one would be under 76-6-1105, which is possession or use of another's identification documents. That's neither a CIMT and it's not an aggravated felony either. Even if you have to take it as a third-degree felony, we've done that numerous times. We've taken it all the way through the system, all the way through the Board of Immigration Appeals, and it has been found to be neither. But when you get in the felony arena, you got to be careful, because there is another ground of inadmissibility that says if you have 5 years or more in the aggregate of convictions or sentencings over your head, even though you didn't serve the time and it was suspended, you are inadmissible. So let's say your client took a third-degree felony for possession or use of another's identification documents, and then they also had a Class C misdemeanor back in the day for driving on a suspended license. Theoretically, you're over the 5-year aggregate, so you got to be really careful. Another one that we've already taken and have ferreted it out and it has worked is not forgery, but possession of a forged writing device, which means you didn't actually do the forgery, you simply possessed the forgery. That is a Class A misdemeanor. There's already BIA, Board of Immigration Appeals, case law that we have that says that one also is not a CIMT and not an aggravated felony. I think they wanted me to give 5 minutes for questions. Was that what it was, Lori, or was it 10?
We don't have any questions, so keep giving us information.
Okay, well, are you sure? Because you know that I'm long-winded.
Actually, I kind of do have one question.
Yeah.
And that is there a priority between resolving the immigration matter before the criminal matter or vice versa? Is there a statutory priority or a policy priority?
No, there's not. And sometimes you play the system against itself. That's a great question. Don't get mad at me, everyone. But one time I had a guy who got found with 1,800 pounds of marijuana in his camper. And it was a 72-hour fail to file by the DA's office. So he got released into ICE custody. We held the hearing within 2 days, and I stipulated his deportation. He was deported before he ever had to pay the 1,800 pounds of pot penalty that he was going to face. So sometimes we'll play it against each other, right? And that's just, you try to call that good lawyering. Some may say, well, you're not, I don't know what some would say. But there's also scenarios where I have literally asked the judge, do not release my guy, judge. And they'll say, why? It's a Class B. Yes, I know. But if you release him, he's going into immigration custody. He's going to Vegas, just so everybody knows. Vegas is our immigration holding facility. There's 3 places in Vegas they go to: Pahrump, Eloy, and Henderson. So they won't stay here. And if I have a viable immigration case where I can file something for relief, I don't want them to go to Pahrump or to Eloy or Henderson with that conviction, especially if I can resolve it with the prosecutor to a lesser offense, or I can get something done first. So if the client has a viable option, you may find yourself arguing with a judge on a Class B, which you would normally ask for someone's immediate release. You would ask them, hey, please don't release. Let me negotiate this first. Let's get a plea done. Let's get a sentencing done. That gives me the option and the ability to say to the immigration judge, look, judge, I know what it started out was, but now here's where we're at. So that is a scenario where you can play it both ways.
So I have another question, and that is, in criminal law, frequently the statute is as interpreted by the court. Mm-hmm. Is it the same in immigration law, or is that just strictly the statutory reading?
No, it's the same. There are scenarios where it's the same. They have to interpret, for example, CIMTs. As Ysabel pointed out, there's no laundry list of CIMTs. There's a ton of them out there. So there's a lot of statutory interpretation. And guys, I didn't dive into the categorical approach, modified categorical approach on the ways to read statutes and whether or not they're divisible, because that is a whole other level of complicated that we don't even want to get into today. I guess the most important point, Lori, is here's my cell phone. It's 801-635-8746. I would way rather just have you call me so I can help you instead of having to file something in the court that says the Padilla advisal didn't take place or was inappropriately given, because we get a lot of those and I don't like them. I'd way rather an ounce of prevention, right, is worth a pound, whatever they say.
Well, and that was going to be my final comment, and that is, in areas like this, it doesn't make sense for someone to have a client walk into their office, someone who practices corporate law, and say they can do a crimmigration case. Mm-hmm. I mean, we have people who are experts in this field, like in my field, when I was practicing. They're there for a reason, and those are the people you should seek out. And for that reason, I'd like to thank Adam and Ysabel for presenting today. I'm glad I don't do this because my head is just swimming, but I appreciate the information that was provided, and I think it's very helpful for everyone that was able to be on today. So thank you very much, and I hope to see you at a future CLE. Thank you, Adam, and thank you, Ysabel.
Thank you,
You're welcome.
Bye.